You've seen this photo. It's one of the most famous selfies on the internet. A grinning, crested macaque looking right into the lens. It's been a meme and a viral sensation. But behind this smile is almost a decade-long legal war that forced the legal system to answer a bizarre question. Can a monkey own property? In 2011, British wildlife photographer David Slater was in Indonesia. He'd spent days befriending a troop of macaques. At one point, he set up his camera on a tripod, adjusted the settings, and stepped away. A curious male named Naruto stepped up, grabbed the remote shutter, and started clicking. Most were blurry shots of the floor, but one was a masterpiece. For Slater, this was the shot of a lifetime. But the trouble started in 2014 when the Wikimedia Foundation, the folks behind Wikipedia, added the image to their public domain collection. Slater argued that he engineered the shot. He traveled there, set the lighting, chose the lens, and positioned the camera. He told the BBC that while the photo made money at first, once it hit Wikipedia for free, his income vanished. In 2015, PETA filed a lawsuit against Slater and his publisher Blurb, but they weren't suing for the public domain. They were suing on behalf of the monkey Naruto. PETA's argument was that the Copyright Act doesn't explicitly say the author has to be human. It just says the work has to be original. If they won, Naruto would be the first non-human animal in history to own property. PETA wanted to manage the royalties to protect Naruto's habitat. The courts were skeptical. In 2016, a judge dismissed the case, stating that animals don't have standing in court. Basically, you can't sue if you aren't legally a person. PETA appealed. But before the final ruling, Slater and PETA reached a settlement. Slater agreed to donate 25% of all future revenue from the photo to charities protecting Naruto's home in Indonesia. However, the Court of Appeals refused to drop the case just because they settled. They wanted to set a precedent. In 2018, they ruled definitively animals cannot hold copyrights. They even took a jab at PETA, suggesting the organization was more interested in its own publicity than Naruto's legal rights. Today, the Wikimedia image is still there. Slater still sells prints, and Naruto's still in the Tenkoko forest, presumably unaware that he had a legal team in California for 3 years. This case might seem like a joke, but it forced the law to draw a line in the sand, and that line is getting blurry again. Today, we aren't asking about monkeys. We're asking about AI. If a human sets the stage with a prompt, but an algorithm presses the button, who owns the result? Under UK or EU law, Slater might have won. They focus on the free and creative choices of the photographer. But in the US, the who touched the shutter remains the golden rule. What do you think? Should Naruto have gotten the check? And does it matter if an author is human as long as the art is good? Drop a comment below, hit that subscribe button for more bizarre legal deep dives, and I'll see you in the next one.